The nomination of a guardian of a minor. Hi, I'm Darren Findling of the Probate Pro. We're going to cover this really great document. It is information that's really invaluable because many people don't have full estate plans. They may not have a will. They may not have gone through the efforts of nominating a guardian for their minor children in their estate plan. We all know that that's a possibility as part of comprehensive estate planning. But what about all those people out there that have never done any planning but are fearful that what happens to their minor child or children in the event that they die, become incapacitated, or no longer can provide for that child or children? So Michigan Statute provides that in the similar way that you'd create a will, you can create a very simple nomination of a person to serve as the guardian for your child or children in the event that you died, are incapacitated, or unable to care for your children. There's no form, though. There's no one size fits all here. It's essentially a drafted document, and I'm going to go over some basic concept language. What's really important here is that I strongly urge you to work with a skilled, competent probate practitioner who does this area of law rather than simply rely on this language. This is very basic template language to give you a sense of how simple it is to create that nomination. It also can be done typed out. It can be done in writing as long as you comply with Michigan statutes for purposes of the execution of the document. We also believe that because nobody knows if somebody's going to be moving to another state, we want to bolster this document with additional requirements to hopefully allow you in another state to be able to utilize it, such that if you are starting in Michigan and then you move to another state, each state has specific state laws about the effectiveness of this nomination. Now remember, the nomination doesn't create a guardianship. It nominates who your preference is to serve in that role, so that if you do go to establish a guardianship after, when I say you go, somebody goes to establish a guardianship after death or incapacity, there is a nomination in place. Now there's a few parameters here. One, the person has to be unmarried. The minor actually has to be unmarried. And then there's another issue here. If both of the custodial parents are not doing this, that just signing, for example, if the mother does this but the father doesn't and they're not married, creates a real conflict here, because if the mother appoints, for example, the maternal grandmother as the guardian, but the father's still alive and then the mother dies, well, the father doesn't, his rights don't just simply vanish by virtue of the nomination by the mother. So it's important to holistically plan this document. Think about the circumstances. If you're a single mother or a single father, then of course you'd have the highest order of priority for purposes of nominating. Let's work our way through the general concepts here. One, you identify the name of the person that you're executing this with no duress, and you're of sound mind. You're nominating a third party. In this particular case, I got grandma being nominated, and we're asking them to serve as the guardian of the minor child. There's additional information about the child, and it states that the nomination should take effect upon the death, incapacity, or the inability to care for the minor child. Also, I've added an alternate guardian provision here in the event that primary guardian is unable to serve. Maybe they've passed away, or they're no longer able, or they don't want to do it. You can nominate an alternate. And again, there's an execution provision here that's dated, it's signed. Michigan law requires 2 witnesses. We want a notary also. We want to kind of enhance the document so that if it needs to be used in another state, it can be used in another state. Again, this is the most basic information to comply with the statutory requirements in Michigan, but we want to add additional language potentially or requirements so that if you do go to another state or maybe even another country, there is a writing in place, because not every state has this particular language in their statute that says that you can nominate somebody within a writing in this particular manner. Now, again, we strongly urge you to do more comprehensive estate planning. That would include a will, a power of attorney, a patient advocacy, maybe even a trust. Comprehensive estate planning to ensure that all of your needs are met, not just this particular aspect of your concerns. But we do know, based on talking to clients all the time, that this concern about who would care for their child or children upon death or incapacitated is on a lot of people's minds. So we wanted to show that this particular document can be signed independent of other estate planning documents or incorporated within larger estate planning documents. If you've got questions about this document or any probate or trust related issue, visit us at theprobatepro.com or call us at 833-PROBATE.